Good morning, Ms. Woods. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
March 26, 2025, in Harris County, Texas. Officer was dispatched to a disturbance call. Officer met with the complaining witness who stated that he and the defendant were in a sexual relationship. Complaining witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complaining witness in the face, head, causing pain. The defendant also ripped the complaining witness's shirt, scratching him in the process, also causing pain. Officer observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want
He
to.
does not.
Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. I am warning you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? You have the ability to hire a lawyer. We can have you fill out an application. I'll take a look and see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive. And then I'll take a look to see whether you qualify. I'll have you sign a receipt with Victoria. We'll give you the application, then we'll have you take your seat in the jury box. Thanks.
This way.
Run around.
Yeah, I want to go back to bed. Good morning, Mr. Salas. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand, grass median, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all 4 tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway. What was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said that 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness tires were blown out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description, running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed Water Creek, then climbed the fence attached to a private residence. And fled on foot for approximately 0.4 miles before he was later detained by a Houston Police Department and turned over to deputies. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant have red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, knows to be represented cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform the standardized field sobriety tests. Those were administered and the officer observed success exclusion on the HGN. The officer did not administer the walking tour of the one next stand due to defendant injuring his feet while fleeing. Defendant considered to a breast sample, which was not completed due to interference being detected. The officer obtained a search warrant for defendant's blood, and there was a blood draw.
Okay.
Your Honor, may I comment?
Please.
I might have missed something, but besides state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
What I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
Take your time.
Yeah, all I heard is going somewhere. It doesn't say he was driving anywhere.
There's times obviously, they give you why they might refollow, but might have been the wrong corner. Sometimes they get fading, it's getting go.
I'm not sure, Your Honor, there was anything additional. This is kind of like in this mirror.
Hey, look at
Good to
it.
see you again, Your Honor.
Yeah, what's up, man? Good to see you. Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up with my client.
Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4 identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said that RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operations.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him. And
He said a Mexican driver swerved in front of him. Is that what he said?
told him no Tango Palace, or I don't have papers. Salas said that other driver was in a gray Toyota, telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink.
Yeah, I mean, I think if they-
He was operating the vehicle at the time of the accident.
And you have the other person say something, right?
they
I
say
thought,
that it was. They identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they believe, based on the circumstances, that it was a driver. I don't know if the witness actually saw him driving. What we have to prove the driving facts is that Reeves fired to believe prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. It was found nearby. was observed coming out of the grass nearby. By the other driver.
Although it's an admission, Judge, there needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence, but don't kill anyone. Do you understand?
Yes, John.
See,
Thank you, Your Honor. Are there any conditions you're imposing?
if you were charged with theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So she, it's already been found, but this case is really old. She didn't come to court. So it was just kind of, she got rearrested for the same charge.
Okay, where's this from? If you don't mind.
Your Honor, I'm sorry, I did just.
Needs,
Eames?
need, N,
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though? With that one.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Okay, can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
They said that they're going to keep the offer.
I spoke to them this morning.
Okay.
So she's gonna complete this class this week, and I'm gonna send it to them for dismissal.
Okay, this case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand? You get no more resets after that.
Okay.
Okay, all right.
Thank you, Your Honor.
So Felicia, she can get today.
You do have a license, right?
I was working on getting it fixed. It was non-eligible.
You don't have a license and liability insurance in your name, don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
I was
You-
working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive hereforth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand? All I'm asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is.
Discovery complete?
I believe it is, Judge. I'm trusting.
Judges, it's the problem is it's the same transaction out of the felony court, out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try to really hard to find out because she's hoping
Right
that.
here.
Yes.
Mr. Gold was here. That's the lawyer.
Yeah, I saw him today.
Did you speak to him? And does he know the,
Yeah.
okay, so I guess he knows the situation.
I tell you right now, Judge, I just better. As far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed because obviously they don't give it to us until the case is closed. But apart from that,
I mean, does that really come in this case anyways?
It can. There, I mean, so typically the things that would be in there is typically they do an interview with defendant, they do an interview with kids.
I mean, unless it's relevant, I don't know, but.
Yeah.
Um,
I mean, but you are right. I mean, it is a case by case basis.
Can you tell me when that felony's reset to?
Felony is reset to the 21st.
and is there an offer in the felony case?
I believe the note is, I mean, essentially the offer upstairs is that if she takes something on the misdemeanor, then we'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha, 421, Judge?
21, right?
Is there any
I would
way
imagine
we-
that's probably a global offer for everything.
Can we go 422?
Sure.
Okay, that's,
But then she'd be coming that day and then the next day. She's on bond.
right, I got you.
It's up to you.
But hopefully I'll talk to her. If we can get the deal together, then I might just bring her back before then to get it done. Like
Okay,
I'm
but
supposed to
after
do.
that setting goes clear trial.
I got you. Got you.
All right, John.
Thank you, Judge.
Dude.